And the centerpiece of the day is this upcoming panel. We are absolutely honored and delighted that three of Canada's most respected jurists, the three now retired judges who have presided over the three public judicial inquiries that have been held dealing with national security issues over the past 10 years, have agreed to come together and share with us some reflections and lessons learned and perhaps a recommendation or two for the future. So I'm now going to turn it over to Nathalie des Rosiers, the Dean of Law, the Common Law faculty here at the University of Ottawa, who has very kindly agreed to be the moderator for this session.
Merci beaucoup. Thank you very much, and welcome to this fabulous panel where we need to learn a lot from. We will proceed in the following way. Each of our panelists will have 15 to 20 minutes to make initial remarks. I will first introduce them in the order in which they will speak. And thereafter, we'll have a couple of exchanges at the front and then open the floor to questions. We're so delighted to have this panel. I think it's a great honor, and I think it's so timely to benefit from the wisdom that has been accumulated. We owe it to ourselves to not forget what we have learned before. Alors, pour commencer, we will hear from the Honourable Dennis O'Connor, who, as you know, was the Commissioner for the Commission of Inquiry into the actions of Canadian officials in relation to Maher Arar. And certainly I think the Honourable O'Connor has a long and distinguished career. He was at Bourdon-Ladner-Gervais, where he's now counsel, is returned to Bourdon-Ladner-Gervais. He was the Associate Chief Justice of Ontario, was appointed at the Court of Appeal in 1998 and served in the position Associate Chief Justice from 2001 to the end of 2012, where he retired. I'm not going to go to all the honors that were bestowed on our panelists, but certainly just to say that he has received many medals, the Advocate Society, the Toronto Lawyers Award, and he was inducted in the Beaver Clan of Crow Tribe in the Yukon Territory as well. So we're delighted to have him with us. After that, we will hear from the Honourable Frank Iacobucci, who headed the internal inquiry into the actions of Canadian officials in relations to Mr. Almalki, Abou-Elmaati, and Nureddin. And the Honourable Iacobucci had a long and distinguished career in many areas, in private practice, in academia, in the government, and in the judiciary. He retired from the Supreme Court in 2004. But previous to that, I had been a Dean of a law school at U of T, had done various positions. He was certainly a Deputy Minister of Justice for the Attorney General, was Chief Justice of the Federal Court of Canada, and certainly has been very active recently as well in Aboriginal issues as well. So he's authored many books and certainly has had many awards and is a companion of the Order of Canada since 2007. And finally, we'll hear from the Honourable John Major, who retired as well from the Supreme Court of Canada in December 2005 and joined his law firm of Bennett Jones. He was the Commissioner for the Commission of Inquiry into the investigation of the bombing of Air India Flight 182. And he is now presently the Commissioner for the Air India Commission that's currently underway. He has also a very long and distinguished career. He was appointed to the Alberta Court of Appeal in 1991 and was appointed in 1992 to the Supreme Court of Canada, which he did until his retirement. And he holds honorary doctorate from Concordia, Université de Montréal, University of Calgary, and University of Toronto. We're so delighted to have accumulated here so much wisdom. So without further ado, I'll let Justice O'Connor.
Thank you very much, Nathalie. Let me start by saying congratulations to Amnesty International and to Alex Neve for putting together today's program. I think it's terrific that there's such a strong turnout, and as I sat here through the morning's proceedings, to see that there was so much energy and interest in the important issues that are being discussed here today. So I just, hats off to you, Alex, and to all of the people who work with you in putting a program like this together. I'm just going to take 10 minutes or so at the start to give some reflections about the Arar inquiry. There are going to be questions and discussions among the panel members about certain issues relating to public inquiries, but let me just give the background that, as most of you know, the inquiry was divided into two separate parts. The first was to look into the actions of Canadian officials with respect to what happened to Mr. Arar. That was a fact-finding process. And so the task of the inquiry was to look into what had gone on in the investigations and to report facts. Obviously, an inquiry such as that, there are no legal consequences to the findings that are made. The second part was to make recommendations for the independent oversight of the RCMP's national security activities. And I'll come back to that, but I think it's worth noting that the order in council that created the inquiry was proposed by the government. The way it works in these inquiries when judges are called upon, certainly the government proposes the mandate. There is some discussion, and there was in the case, and the government was very accommodating in any suggestions I had to. But the thrust of the order in council and the areas in which it was directed were directed by the government. They weren't ideas that I came forward with. What we did as we assembled the team is we divided the inquiry into two very distinct processes. And I think there probably are some lessons to be learned, not because of any particular wisdom we brought, but from the experiences that we had in conducting the two processes. With respect to the fact-finding, one of the significant things was that the mandate required us to look into actions of all Canadian officials. And therefore, as a result, we did, both in public and in camera hearings, look into actions of people from the RCMP, from CSIS, from Foreign Affairs, to a lesser extent from Canadian Border Services, and so on. The point there was that it was an integrated investigation and review. And the observation that I made in the report was that it benefited from the fact that there was a single inquiry and investigation review looking across different agencies and different departments. And I think that the wisdom, the government's choice in doing that, certainly from my chair, was apparent. It was good. It would have been a constricting review if I had had to look at only one or some of the agencies, because not surprisingly, there was some interaction between them. The second thing that I'd comment about the process, and this is going to be true about public inquiries or review processes dealing with issues of where there are issues about national security, confidentiality, and information that must be kept confidential, that cannot be heard in public. Now, when I took on the mandate, I had no appreciation of the complexity of those issues and the difficulty in sorting out as to what could be made public and what would have to be heard in camera. It's going to vary from case to case when you're reviewing having a national security investigation in whatever forum as to how much can be made public and how much can be kept confidential. And it's going to vary as to what steps can be taken as to how you make those decisions and so on. And I won't go through that. Suffice it to say that Paul Cavalluzzo, who's here today, who is the senior counsel to the inquiry, I venture spent well over 50% of his time working on this issue as to what could be made public and what could not. I mean, it was a massive task, indebted to him for sure. But a couple of things that when one looks at a process like the inquiry that we were very conscious of that may not be apparent. There's a natural impulse for everybody to say, and I'm in favor of it, as much transparency and as much public as possible, particularly as a judge. I can tell you as a judge, sitting in camera is most uncomfortable because the accountability for our judiciary, I think one of the main planks of our accountability comes through the public nature of our judicial process. In any event, so be it. That's what it was. But two issues that I think that we struggled with once we had determined part can be in public, part can be in camera, is that was there a danger in going in the public hearings with evidence about part of the story that's not complete? Would having part of the story in public create an inaccurate picture because it's not fulsome? And that is a big issue. The second issue that we struggled with is, with going with public evidence, is it going to be unfair to individuals whose reputations could be affected, whose actions are under scrutiny, because part of what they would want to say has to be heard in camera? So that in struggling with this issue of bifurcating hearings between public and in camera, you start with the issue, what, as a matter of national security, must be kept confidential, but then you move into other considerations. And what I can say is at the end of the Arar process, really for two reasons, I think, and I pass this credit to others, by and large, it worked. We were fortunate in terms of the story that could be told public was fulsome enough that the story could be told. That's happenstance to a large extent, but it was. And secondly, once you go in camera, you have huge concerns about people who are affected by what's going on, in this case, for example, Mr. Arar, but others, and you need to gain their confidence that the process which affects them, that they're not being able to see, will indeed be a credible, fair process. And again, this is going to sound like taking my hat off to Paul Cavalluzzo, but I can't do it enough. He gained the confidence of people on all sides of the issues. So that there were certainly people, Mr. Arar and those who were supportive of him, but people on the other side too, that he would carry out the investigation thoroughly, fairly, and which he did, and get to the bottom of it in a fair way. And it was because of that credibility, and I can't overemphasize it, because of that credibility that we were able to complete it, tell the story, and people could make of it what they will. So that's what I'll say about the process, and simply leave that to say that when people are thinking about oversight or review processes for national security activities, I think there are, and I'm not going to go into more detail, there are many lessons to be learned from the experience, and we wrote about it in the report, about the process itself, from the experience that we went through, and we sure didn't get it right the first time. I mean, we learned on the job. The second part of the inquiry, and let me just touch on this, was to make recommendations for the oversight of the RCMP national security activities. We adopted a different process, much more like a university study than a courtroom, more of a round table. The advantage of a public inquiry, looking at issues like that, and making policy recommendations. The advantages are that they're well-resourced, because the public, at least for the time being, is engaged in the issues that gave rise to the inquiry. There's an opportunity for broad consultation from all different interest groups and so on. It was spectacular, the amount of help and advice we got during that part two, we call it part two process, that led to making the recommendations. And so, as you know, we made a broad range of recommendations. And I've been asked in the many years since what my observations are about the action or lack of action with respect to those. Quite simply, my view of it is that when judges or retired judges are asked to do public inquiries, they do them, they issue the reports, they say everything they have to say in their report, they make recommendations. It's then up to the government and the political process and other people to make of what they will, but the commissioner, after having delivered the report, should not partake in the debate as to whether or not the recommendation should be implemented or not, or comment on it. As a result of that, I've been asked a couple times today if I'd give interviews with the press with respect to issues I suspect relating to that, and I hope very politely, I declined to do so. But in any event, those are my opening remarks. Thank you.
Well, thank you, and I want to start off by also commending Alex Nev and the sponsors, the University of Ottawa, President Rock, for their organizing and inviting the conference and inviting me to participate. J'ai préparé mes commentaires dans la langue de Shakespeare parce que quand je parle la langue de Molière, c'est toujours avec un accent de la langue de Dante qui domine. My comments are going to be a little bit about the inquiry, just as Dennis has stated about his, and then I'm going to make some observations, reminiscences, reflections, concerns, and a couple of recommendations, if you like. I'm not taking a lot of time on either major topic or major section of my remarks. The inquiry that I had was basically came from the Arar inquiry, Dennis's report, and it involved through the Ordering Council whether the detention of these three individuals in Syria or Egypt, in the case of Mr. Nureddin, resulted directly or indirectly from actions of Canadian officials, particularly in the relation to sharing of information with foreign countries, and if so, whether those actions were deficient in the circumstances. And secondly, whether there were deficiencies in the actions taken by Canadian officials regarding the provision of consular services to those three men while they were detained in Syria and Egypt. And then thirdly, whether there was any mistreatment of three individuals in those countries that resulted directly or indirectly from actions of Canadian officials, particularly in relation to sharing of information with foreign countries, and if so, whether those actions were deficient. So those were the terms of reference. I had to prepare a confidential report and a separate report suitable for disclosure to the public, and the same queasiness that Dennis described about ex-judges, I share that very, very strongly. It's not easy to do that, a confidential report and a public report. So this was an investigative and inquisitorial proceeding. It wasn't adversarial. Many of the features of the adversarial approach didn't apply, but we tried to make it as fair and effective as we could. Again, I want to emphasize that these were not a trial about and not an inquiry about the three men. It was about the actions of Canadian officials, as was the Arar inquiry that was at stake here, not the conduct of the individuals. It's the conduct of officials. And in setting out the factual background to the findings, I made reference to those allegations, but did so as much as I could, pointing out that these were allegations, these men were not charged with any crime, and that anything I said in the report was not to be taken in any way as an indication that any of the allegations or all of them were founded, well-founded. So it was internal and it was presumptively private, calling itself an internal inquiry, and inquiring that I take all steps necessary that the inquiry be conducted in private, except to the extent that I determine to ensure the effective conduct of the inquiry, specific portions should be conducted in public. And that was one of the things that I had the opportunity to give comments on, the exception. And there were exceptions to having everything in private. I have to say that this inquiry came about through, as I repeat, through Dennis's recommendation, and he indeed recommended that this matter be done in a manner that would not be a full-scale public inquiry. Because of what he said about national securities involved, that can be complicated, protracted, and expensive. We had no template for this inquiry, and we had to, if you like, conduct it in the way we thought was appropriate under the circumstances. When looking at the question of consular services mistreatment and detention, one had to formulate tests as for the interpretation of the mandate. And that's where we had a public discussion, and that's where that aspect of the inquiry was very, very important and helpful, because, as Dennis has said, we gained a lot from the submissions we made, and we ended up with a test that I think I would stand behind still today, whether the actions can be said to have likely to have contributed, not caused, but contributed to the detention or mistreatment of the individuals concerned. And we went on to define what we meant by a deficiency as well. As I say, we struggled with what was the appropriate test. Remember, inquiries are not about civil or criminal liability. They're about what has happened and what, in a way that is properly determined, and we came up with this test. And we have to remember here that in making findings, and in this context, one never gets the cooperation of foreign governments. I mean, we didn't get Egypt or Syria. Syria came in very, very late in the process when we were facing a deadline. We didn't have anything from the United States, and I suspect perhaps Canada wouldn't participate in foreign inquiries either. I just make that as a comment. So you don't get the full picture that you would like to get if you were finding in, say, a court of law. So the conclusions we arrived at, yes, there were actions of Canadian officials that contributed, directly or indirectly, to, and in different ways, to the detention, to the mistreatment, and we included in mistreatment torture. Again, that aspect of the definition of mistreatment came about through the public aspects of the inquiry, and we also saw some deficiency in the provision of consular services. Now, I had no mandate to make recommendations, but I would maintain, and I don't mean this in a argumentative sense. I just mean it, that if you're asked to make findings and you find findings of some deficiency or some failing or some contribution, there's an implicit recommendation to fix it. So I leave that as an editorial comment. Then now I get to my observations and concerns and lessons learned. Well, there's much that can be said. But I want to point out that some 3 years ago in Montreal, Alex, you were at the conference in Montreal on terrorism. I said this in 2011, that there's troubling evidence of Canadians traveling abroad to join terrorist groups, such as Al-Shabaab in Somalia. And with this global increase in terrorist numbers and Canadians joining terrorists abroad, the fundamental question arises as to what can be done to understand more deeply the underlying reasons for the increased radicalization. Of course, criminal laws and enforcement are necessary, but the need for better ways of understanding why people become terrorists remains a most challenging issue. What are the ways we can be proactive in this area? Whom we should enlist to help us in this respect, and what are other countries doing in this approach are a few of the questions to ask and determine. My point here is that the laws and the application of our laws are reactive, and they're necessarily so. But, you know, we have been struggling for years as a society to talk about crime prevention rather than crime enforcement, criminal law enforcement. And it's very, very difficult. And in this area, it is very difficult. But I heard yesterday the commissioner of the RCMP saying, yes, if we're going to do more of this, analyzing in a proactive way, this Canadians becoming terrorists, that's going to be very expensive, to say the least. But it is a concern. Another concern that I gleaned from this assignment of my inquiry was the spillover effects. And by that I mean we see freedom of religion, freedom of association, freedom of expression. These are all fundamental freedoms that get triggered when we look at this question of terrorism, and we all know that. But what bothers me a lot is particularly bothers me a lot, is the spillover into tainting a huge community, but still is a minority community, and that's the Muslim community. And that is a concern. And we have historical examples in our country of that occurrence with the Japanese Canadians, albeit in wartime, and indeed the Italian Canadians that affected my family. I was the son of enemy aliens, had to report to the RCMP monthly. And I remember going on a couple of those trips with my mother in that respect. I'm not saying that in any sense of grievance, but I say it because we have to be very, very concerned about the overreach of what we're doing in the struggle against terrorism and to marginalize groups in our society. The other thing that I'm still concerned about is the information sharing that takes place. There's a greater need for intelligence, global and regional, but we also have to worry, and both Arar and my inquiry full of great examples of the concerns about information sharing. And I think that is extremely important. I worry about whenever an incident comes up, even the ones of recent weeks, we immediately resort to what changes in the law should we make? And I wonder whether that exercise is as important as some people think it is. It's maybe, again, I come back to proactive thinking as well as reactive responses. And I believe that we should be very careful about rushing to change laws immediately because of the dangers that can pose. Another point that I would like, in these reflection part of having done this inquiry, it's very, very important that judges on the line in the courts are not co-opted into being officials of the state, that the line between the judiciary and the executive gets blurred. And I say that because judges ultimately have to rely on the executive for the information they get. We had to rely on the executive for the information we got to conduct our inquiries. We got certificates from officials to say we've been given all the relevant information, but sometimes you don't get the relevant information because government is big and things can slip through the cracks. But in this respect, judges in terrorism cases have a very special role to play. And if they are not given the full information that's complete and true, it is very difficult. Now I want to come to two suggestions that occurred to me in my work in the inquiry and in another matter that I was involved with. And that is, I believe that it's time for us as a society, in setting up inquiries, a commission of inquiry or a special review of a matter, when it's carried up, there should be a follow-up public report provided by an independent reporter or reviewer on what changes or proposals from the commission have been adopted and which have not, and with the executive or legislative branch providing an explanation for rejecting the recommendations or the proposals. Too often we get these reports and recommendations, and they just gather dust on the shelves. I'm not saying all recommendations should be adopted. That's not what I'm saying. Of course, people should reflect on them, see what the implications are. But there ought to be a way of having more transparency and accountability. If it's important enough to have someone spend a lot of time on it and a lot of money involved and a lot of people also involved, why isn't it important to get a fuller understanding of what came out of that report and why it was not? Its recommendations were not adopted or recommended, or if they were, in what form and why. I think an amendment to the Inquiries Act would be acceptable in the public eyes as being more transparency and accountability, and perhaps more progress on these important issues. And the second suggestion comes out of my doing some work with the Afghanistan files in connection with the turning over of Afghan nationals to the Afghan officials when there were allegations of torture and so on. That showed a little bit of a showdown between the government of the day and Parliament. And I think it's time that Canada, through the Westminster model, has a better way of ensuring the proper role of Parliament as its, if you like, the great inquest of the nation, in holding government accountable, but also not strangling government, not revealing publicly national security measures. There ought to be a mechanism by which the government of the day and parliamentarians can have dealing with these very sensitive subjects in a way that respects the democratic process and the accountability of government to Parliament in its conduct of foreign affairs. Thank you.
Thank you. The Air India incident happened 29 years ago, so I think I should back this up a little to tell you those circumstances. Air India Flight 182 was blown up over the Atlantic Ocean on June the 23rd in 1985. There were 329 casualties, 250 were Canadians. Because it was an Air India plane, the Canadian population, including myself at the time, thought that it was obviously an Air India problem and had nothing to do with Canada. We were slow to recognize the fact that Canadians were involved. The authorities launched an investigation, and I'll tell you the outcome of that shortly. But first, it was really quite a simple plan that the terrorists implemented. The person whose identity is not known is the man who showed up at the CP ticket wicket in Vancouver with a one-way first-class ticket to Toronto and wanted to check his baggage through to New Delhi in India. The CP desk clerk said she couldn't do that because he was only confirmed as far as Toronto. He put up such a fuss and people gathered behind them, that the woman relented, much to her regret, and checked the baggage through to India. The consequence was that he loaded the baggage, but he himself never got on the airplane. Things have changed since then. Now they relate all the baggage to the checked-in passengers. Back then, it was a practice, but it was a practice that in this case wasn't followed. We know that the Air India, the cause was rooted in India. The Sikhs wanted to carve out a portion of India in the Punjab that would be their country. Prime Minister Gandhi in India was very much opposed, and after some skirmishing, she ordered the Holy Temple to be attacked. And the Indian army invaded the Holy Temple, shot things up, there were casualties, and then they retreated. The Sikhs, in revenge, assassinated Gandhi, and it's interesting that her two bodyguards assassinated her because the two bodyguards were Sikhs. While that was going on, and a little before that, in Canada, we had an interesting problem. The RCMP had come under scrutiny for their behavior. There were various things that they were accused of, attacking or tapping telephone calls without warrants, and a variety of things that came to a head when they burnt a barn in rural Quebec. You may remember that event. It received a fair amount of publicity. The RCMP justified it on the basis that Black Panthers and others were going to meet with separatists. They were going to tap telephones. They were going to do a lot of unsavory things. In the result, the RCMP burnt the barn. As a result of that action, the Prime Minister Trudeau at the time thought he should call what's been known as the Macdonald Inquiry. The Macdonald Inquiry examined a lot of things. In fact, they were appointed in 1976, and their final report was not made until 1984. There were 4 reports. It was a 3-man panel. The chairman was Justice from Alberta, David Cockrell MacDonald. He was known affectionately in Alberta as Daisy. Daisy was a very conscientious judge, and he took this matter seriously. He bought a house and moved to Ottawa, and there were hearings that were on and off for that 7-year period. There were innumerable suggestions, but the one relevant to today is that he said that because spying involved unsavory activities, it was not appropriate for RCMP, who the public visioned as standing with children on Parliament Hill, having their picture taken, to be involved in the undercover work of the RCMP. So he recommended that the national security be taken out of the hands of the RCMP, and a new agency should be created. Well, how do you create a new agency? CSIS came up with the notion that they would get their recruits from the RCMP on the basis that they could come for 2 years, and if they didn't want to continue, they could go back to the RCMP. This immediately caused a problem because those that left to join CSIS were considered, for lack of a better word, traitors, and the RCMP wanted nothing to do with them, which was not a particularly good way of establishing cooperation. To move back to Justice MacDonald, and this is pure gossip, but you've sat through a lot of facts, so you might want a little gossip. Justice MacDonald had his eye on the Court of Appeal in Alberta, and he thought, I assume, that by being thorough in this report, the path to the Court of Appeal was paved. Unfortunately, the Prime Minister didn't take the same view. And MacDonald, after the inquiry, waited for the call, and the call never came until Trudeau left. A new government was appointed, and so was Justice MacDonald to the Court of Appeal. But the old Henry end to the story is that he died before he had his first sitting in the Court of Appeal. So there's a lesson to be learned in being too thorough when you're asked by the government to do anything. The problem in this particular case was clearly the lack of communication between the RCMP and CSIS. I believe it's common knowledge that if each had known what the other knew, they could have foiled the attack. They were on common ground on a number of things. There was a general warning put out in June that Sikhs should not fly on Air India. And everyone agreed that that was the situation. Then Air India put out a more urgent message saying that something was going to happen in June. Well, our authorities interpreted that as Air India's way of cutting back on their expenses for security by raising this alarm and having the RCMP do their security work. It's hard to believe, but that was the excuse. They claimed, and both of them agreed, that there was a certain amount of knowledge that they had before the event. But they claimed there was nothing specific to Air India. Well, that was contradicted by the evidence of the former Lieutenant Governor Bartleman, who testified by accident. He ran into Commission Council, said something had been bothering him, and what was bothering him was the fact that he saw a communication that indicated there was going to be some kind of activity, probably a bomb, on June 23rd. His evidence was that he told, or he attempted to tell the RCMP, who brushed him off. They weren't interested, said in effect they could look after the investigation. There was a lot of time spent by the government trying to show that that document never existed. And they explained their procedure. And the irony of explaining the procedure was to prove that there were several other documents that they couldn't find. So documents they knew existed in their clever scheme, they couldn't find. So it made Bartleman's evidence even more credible. All that to say is that if, as I said earlier, each side had known what the other did, if Bartleman's evidence had been taken seriously or taken at all, this explosion and loss of life would not have happened. The lesson to be learned from what you've heard my colleagues say is what it is the purpose of a public inquiry. The government, it's said, and at times I think it may be true, that one way of getting a hot subject out of Parliament is to call an inquiry. And that they call the inquiry for the purpose of getting people out of Parliament, the politicians off the floor. The subject goes to the inquiry, and if the inquiry takes long enough, the government hopes most people will pay no attention to it. To ensure that people will not pay attention to it, they frequently don't implement any of the recommendations. As I look back on Air India, I think one of the mistakes I made was to take them seriously, that they wanted recommendations, and diligent counsel came up with 60. And they were not frivolous. They were serious recommendations. The most important recommendation of the Commission was that within the framework of the Justice Department, there should be a national security advisor appointed. In effect, the friction between CSIS and the RCMP was so intense that there had to be some way of refereeing the disputes. And the recommendation was that there'd be a single national advisor appointed who would serve that purpose. Well, when I think he was then Justice Minister Tays was commenting on the report, and I should back up to say that the report makes it clear that we were not talking about a department, but we were talking about an individual. It would be a mistake, the report says, to have a department because the red tape with the department would slow things up. Tays, speaking publicly, said there were a number of things that they would do, but he couldn't agree with the suggestion that there'd be a Department of National Security appointed, because that would involve a whole new department in the government, several personnel, and the usual expense. Now, there's two conclusions. One, that Tays never read the report, and that may be the more charitable, or that he was so stupid he didn't understand the report. In any event, I don't think that there's been a national advisor appointed to this point. I think at this point I can cease and let the audience turn it over to them for questions.
I don't have any stories as good as that, but just sitting, listening to Jack explain that the recommendation that came out of his inquiry was that there be more cooperation and integration and national security advisor, however, that there had to be coordination. Okay, and then you move over and you look at, we were a year or two earlier, there had been interaction between a number of agencies, as I said before, RCMP, CSIS, and DFATE with respect to Mr. Arar's case. But what the inquiry demonstrated is that assuming you get that interaction and integration and perhaps even more cooperation, which Justice Major's recommending, what our inquiry, I think, was one of the strengths was it provided an integrated review so that you got the totality of the cooperation came before a single reviewing entity and so on. And in that sense, they go very much hand in glove. But if you're going to have the hand, it's a good idea to have the glove.
So on making sure we continue to have more gloves and more hands, my first question is, if you had to do it again, would you do something differently? Is there something that you would, upon reflection, that you would do differently, that we could learn if there's new inquiries that are set up?
Well, I'm not going to admit in front of this crowd that I would look, I've made errors in everything I've done in life. If you're not that honest, you're trying to fool people. I had the benefit of Dennis's report, but I didn't stop at that. We took steps that I think he didn't have to do. But I really do wish that when we have a global reactions to terrorism, and I do know that information sharing has taken place in greater measures than ever before. But I do think there should be a continuation of that at the inquiry level as well. But that's asking too much because it gets into sovereignty and so on. But we were really missing fundamental and important pieces. When we interviewed the three individuals for a long time, and we were able to say that through other sources that we received, that their accounts stood up. But you know, we had to do that on our own, so to speak. So as I say, there ought to be better ways of having international cooperation. Certainly at the political level, you hear it all the time. The rhetoric, yes, we work with our allies and so on. But when it comes down to these kinds of issues of individual liberty and freedom and of serious consequence, that sort of dissipates in the kinds of inquiries that have been asked. So I think there has to be ways of dealing with that. Now, what doesn't prevent us from making the decisions we have to make. We have to make decisions. We had to make decisions on inferences to draw. And that's what judges do all the time. And that's what inquiries have to do and reviewers have to do all the time. But I just, again, I would put a plea in for more international cooperation on these things.
On what I would do differently? Well, I think one of the things I would have done differently was not make as many recommendations, because obviously they were incompetent to deal with 64 recommendations. But there were 5 that I think bear repeating. One was the appointment of a national security advisor. The other was X-raying cargo. I don't know how many of you sit comfortably in your airplanes knowing that the cargo has not been X-rayed. Baggage is X-rayed. Cargo, unless you're going to the US, is not X-rayed. We also recommended, probably the RCMP like this, increased funding for both the RCMP and CSIS. But of interest was we also dealt with homegrown terrorists, which is a topic that has come up for review again. The terrorists were a little different in that their objective was to create a homeland in India, but nonetheless, they were born in Canada and they were converted to that particular cause. The other aspect that I think is important today was the financing of terrorists. And there's quite a bit in the report about how terrorists manage to finance their activities. A simple example would be a rich Sikh would wear jewelry into Canada and leave it. It would be sold and the money used for purposes. They would buy bank accounts of existing Sikhs. So there was no transfer of funds, but they would simply pay the owner of the bank account what was in it, and the money was turned over to them. So they were able, on a fairly small scale in number, to raise substantial sums of money. And I think that's still, that activity parallels what the government is presently afraid of with the ISIS movement.
I guess I would say we were very naive at the beginning about the challenges of running an inquiry with so many national security confidentiality issues. And I think we tried to take it on at the beginning and determine those and try to resolve those issues. And it became clear that there was going to be disagreement, there was going to be litigation and so on. We'd never get through the inquiry. So that were I to start again, I would have started where we shifted gears after about 6 months and just decided we would go with the public hearings on whatever the government agreed could go public, and that we would fight the issues as to what should be made public once at the end in the context of the report. Happily, that process worked out, and gradually more information was released, and while there was a little dispute at the end, it wasn't long, and importantly, very importantly, it did not hold up the inquiry. It enabled us to get through and not get derailed with appeals up through the court system. The one takeaway, though, I would say is important when these issues are confronted in the future, there is now far more judicial writing on the subject. So that post 9/11, in the era we were doing it, there had been some decisions from the federal court, and they were useful, but that jurisprudence has matured now, and we've got some very helpful decisions out of the courts giving guidance to everybody about what needs to be kept confidential. And there's still room for disputes, for sure, but it is a much more traveled landscape. And I would hasten to add that in some of the public inquiries, in ours as well, we did decisions when I made rulings and so on, so added something to that. So that I would hope if there are another inquiry or another review process, that those issues that so tormented us, cost a lot of money and so on, that they will be more easily resolved because of what's gone on in the courts since that time.
Can I just add a footnote to that, please? Because we're in an academic institution, and one of the things that I would like to underscore with Dennis, relating to Dennis's point, is the centers and institutes, human rights, security, intelligence, and so on, that have just flourished all over the world. And those initiatives are very, very important in terms of just greater understanding and greater analysis and greater exchange of ideas on these questions. It is battling every kind of democracy, whether progressive or not. And I commend the academic community for their efforts in this respect.
That's music to our ears, since we have a Human Rights Center here that continues to do great work. One of the questions, I think you, Justice Iacobucci, you recommended this sort of early commitment to having a review as to whether or not they would be, the recommendations had been implemented or not. And I take it probably this would gather some positive reinforcement from you, sir, to having a commitment that eventually there will be a process by which the government has to explain why not, why not have they forgotten to implement some recommendations.
I agree with the principle, and I rely on the ingenuity of my friend Justice Iacobucci to explain how he could convince the government to do that.
Oh, yeah, go ahead. I was going to ask as well, what's the time frame? Like we're doing, 10 years after. Is 10 years the right time frame? Is it 5 years? Is it 20 years? What's the right time frame to ask for that?
Well, look, I'm not going to get teased by Major's comment. This is a question that needs to be looked at, in my view, and come up with the analysis that is appropriate as to the time frame, or whether that would be left to a recommendation of the inquirer under the particular context of that legislation and the ramifications of the recommendations and so on. I don't think it takes a lot. What's the commitment that the government would do this? Well, I mean, I'm not the expert in political matters that Jack Major is, but I would say some parties like to campaign on increased transparency and accountability, and if they see this as furthering the public interest, they'll latch onto it, and they'll do it in a way that is respectful of the democratic process and the powers that go to the leaders of our government. But I don't see it as being all that revolutionary in terms of difficulty.
I think it's a good idea, and it solves another problem, and that is that we in Canada, when we call public inquiries, tend to ask judges or retired judges to do it. And we do that because of the credibility of the judicial office, and indeed our neighbors to the south think that Canadian judges are crazy for getting involved in them. But the one downside, or one of the difficulties, is the one I mentioned earlier, that having delivered your report because of your judicial office, most judges who conduct public inquiries do, as I said I do, they button up and they leave it alone, so that they don't lend their weight as the commissioner to trying to sell the implementation and get in the debate and so on. So if the government were to adopt the mechanism that Frank suggests, an automatic review by an independent person and reasons for accepting or not accepting and so on, it takes the judge off the hook and not feeling that pressure, and indeed I think it facilitates the use of judges, which, by the way, I think on balance in Canada is a very healthy use of judges. It facilitates that.
Good. I'll ask one more question, which is about all your recommendations were useful to the public, and we have a debate in Canada as when is it appropriate to call a public inquiry. Some people want more. Others say, no, useless, too expensive, they're inappropriate in circumstances, and so on. When do you think you are the most helpful? When do you think it is most useful to have a public inquiry? And my second question is, do you think, some people argue it has a therapeutic aspect to have a public inquiry? It allows us as a society to actually deal with our demons or confront some hard truths. Is that the case?
Well, I do think it is one area where I think it's important, and that is areas in which the three of us were involved. I think when you have the conduct of government officials that are at issue, and of an issue that is of serious import, then it seems to me having someone from the outside of that, outside the fray, to come in and be objective and independent, and to look at that very important issue in the coolness of the inquiry. But I don't think when the issue is highly political, it seems to me it should be left to the political, if you like, segments of our democracy, rather than getting judges involved in that. That's a broad generalization. And there may be certain kinds of domestic disasters that call for that intervention by a person that has either, I don't think it has to be a person of legal or judicial background at all, but someone who has the credibility and perhaps the expertise and who would be well qualified, he or she, to carry out that role. But I think it's more appropriate for when government itself is being questioned in some way.
Well, the one circumstance that I think a public inquiry does some good was what happened in Air India, where the families, for the first time, found out what had happened. There was an impression, as I mentioned earlier, that that explosion of Flight 182 had nothing to do with Canada. And in spite of the fact there were 280 Canadians, well, there were about 60 of them showed up to explain what had happened to them after the explosion. And there were widows and widowers, there were people that lost members of the family. It was a tragic event on a human level, forgetting whether or not there should be inquiries. And I think the inquiry had the benefit of bringing some comfort to those Canadians who had felt they were ignored. Now, maybe it could be done in a cheaper way. I don't think that consolation of the victims is really enough, perhaps, to call an inquiry. You can try to help them with psychiatric help and others, but they sat there and heard what had gone on. Picture yourself having lost members of the family, and you hear how the luggage was checked through without checking with passengers. You hear after it got to Toronto, they loaded, Air India had a conveyor belt, but it was broken, so they loaded by hand, and they had a P4 wand that was supposed to detect explosives. They heard funny noises, but the consensus was there was nothing. The dogs, the sniffer dogs, were away, if you can believe it, on a convention. Some would call it a training period, but there were no sniffer dogs at the Toronto airport. There was a sniffer dog provided by the Quebec police in Montreal. But by the time the sniffer dog got to the plane had left. The owner of the dog claimed the dog would have found the explosives. The plane was an hour late. The plane was carrying an engine for repair, so that slowed down the process. But I'm not sure that some of the people, when they heard the absolute carelessness that was involved in all this, took much comfort from it. I think they did take comfort from the fact that they were being heard, and that in the end there was some compensation paid. But that alone may not be enough. But in this particular case, I think it did bring some kind of comfort to them, because they felt for the first time they heard.
Yeah, we in Canada are extremely heavy users of public inquiries. We've had over 400 since Confederation. And some of our major policies have emerged. They were formerly called Royal Commissions, same thing, our health law, bilingual, biculturalism, employment equity. We've also had a huge string of inquiries that resulted from tragedies or when things have gone badly wrong. There's dozens and dozens of them, from mining disasters to wrongful convictions, child pathologist in Ontario recently, and so on. Those inquiries have made recommendations, and while sitting here today, there may be a certain concern that the recommendations of the three commissioners sitting at this table have not been taken up wholeheartedly, or even less. Maybe it has something to do with the three of us, Jack. The fact of the matter is that in many inquiries, when one pursues the history of it in Canada, they have had both the therapeutic and fact-finding effect of exposing what had gone wrong, if it's that type of inquiry. Secondly, the policy recommendations that have been made have been taken up, perhaps not every last one, but certainly the thrust of them, so that we should not write off in Canada the institution of the public inquiry on the basis that recommendations that are made in public inquiries inevitably gather dust. That's not the history in Canada. There are those examples for sure. But I, for one, having been involved in two, I remain of the view that yes, in appropriate circumstances, recognizing that they're expensive and they take time, that they're a very valuable instrument in our public institutions for regaining confidence when there's been a loss of confidence in whatever public institution it has been, and also for making recommendations that can guide us forward. I think that's more strongly the history than one of gathering dust.
We have a couple minutes for questions from the floor. If you want to take the mic, we have one single mic. Please identify yourself and then direct your questions to the
My name is Bob Fife. I'm with CTV, and I want to ask a question to all three judges about homegrown terrorism. We have a slew of laws that were brought in after 9/11, and now in recent weeks, the government seems to have put the pedal to the metal in terms of changes of the CSIS Act would allow protection of informants without, even without the courts seeing them, more sharing of information with Five Eyes. And just yesterday, the RCMP commissioner said that he wanted the power to be able to do peace ponds on his own without having to get the Attorney General to sign off to, in terms of being able to restrict the monitoring or the movement of people. And he even said he wanted greater access to people's internet and electronic devices. And I'd just like to see, which, by the way, our privacy and information commissioners today expressed great concern about that because of the effect on civil liberties. And many of them are saying, in fact, we already have the tools right now. We don't need these. But I'd really love to get the input from the three of you on that, please.
I'll go first and let Jack and Dennis chew me up. You know, that question reminds me of goals and means. We all have goals in life, and we all have goals publicly from a policy standpoint. But we also have to be extremely careful about the means that we employ to achieve those goals. And so the goal here is laudable, without a doubt, to reduce the threat of this disease, which is international. But I believe that when we're choosing the means, we really have to remember that we are in what we pride ourselves in many ways, and that's a democracy. Then has to be a respect for fundamental principles that define a democracy, and that is the rule of law, freedoms that we enjoy daily. And if we rush to the legislative resort, we have to be careful of what we're doing in terms of overreacting, if you like, charging the issue, because we all find it very distasteful. A very wise judge, the former Chief Justice of the Court of Israel, who has had more experience, I suspect, than any judge certainly in the English-speaking world, said this once, that democracy in fighting terrorism has to fight with one hand behind its back, so to speak. But the terrorist doesn't have that constraint, the one hand being respect for the rule of law and human rights and so on. The terrorist has no such constraint. But he said ultimately, democracy will have the upper hand if it responds in a way that respects the balance that has to be observed in choosing the means to achieve the goal of struggling with terrorism.
I think the first step should be for the government to rationally consider what powers they already have enacted, rather than a knee-jerk reaction to a present existing circumstance. And I am reminded of the Canadian and American reaction to Pearl Harbor when all Japanese were rounded up and sent to internment camps. That conduct, later much criticized, highly popular at the time. I can say that because I was 7 years old and have a vivid memory of it happening. I agree, however, that force, if you like, has to be met by force. We can't stand idly by if there's danger. But I think, as Justice Iacobucci said, you proceed with some degree of caution so that 20 years later the government's not making an apology. But you can't sit on your hands while you do that. It has to be done quickly. The government can figure out pretty quickly what powers they've already delegated to law enforcement and what more are needed. But it should be done with some caution.
Just to pick up on that, and it was a point that was made during by one of this morning's speakers, was that the government proposed legislation will be subject to charter scrutiny, so that when Frank says and takes comfort from the fact that we live in a democracy, whatever these proposals are, they will be, because they are government action, subject to scrutiny by the courts. And so that I think one can take comfort that in due course there is that check and balance within our Canadian constitutional framework.
Well, on this note, I think I want to thank all the panelists for a great session. Tellement de sagesse qui émerge. Merci beaucoup. Thank you for all your wise words that will carry us not only for the rest of the afternoon, but certainly in the years to come. There's I think 5 minutes so that the glasses of water can be changed, and then we will resume our proceedings. Merci beaucoup.